a serious argument between Ripple and the SEC has been going on for some time now, and it involves the evidence of Andre Fox, a key witness. There have also been disagreements between the entities regarding the sealing of particular financial records, with the regulator considering these documents to be of crucial importance to the case. The conflict regarding the key testimony, the epic legal struggle that has been going on between Ripple and the Securities and Exchange Commission is each of the United States of America since December 2020 began. During that time period, the regulatory body accused the company of earning more than $1.03 billion through the sale of XRP through an unregistered securities offering. During the course of the previous years, the lawsuit went through a great deal of ups and downs until finally reaching the stage of trial on April 23, 2024. A fresh scheduling order that was centered on the motion for remedies and entry of final judgment was signed by Judge Sarah Netburn not long after that date. Both sides took the necessary steps to comply with the laws, including submitting the required paperwork and providing the essential information that could be helpful in settling the matter. There was a disagreement between Ripple and the SEC on a crucial witness testimony from Andre Fox, which may have made the process more streamlined. The corporation initially contended that the statement is an uninvited expert opinion, but the watchdog described the procedure as standard summary evidence in support of calculations for disgorgement. Therefore, the company's argument was rejected. As part of its official opposition to Ripple's motion, which was submitted on April 29th, the Securities and Exchange Commission insisted that the testimony does not rely on specialized experience and does not render any opinions at all. It makes use of elementary mathematical operations on Ripple's financial records in order to simplify the presenting of the evidence to Judge Torres. In addition, the agency stated that the court ought to reject Ripple's motion. A few days later, Ripple responded by submitting a letter that provided more substantiation for the request that it had initially made. On the other hand, it asserted that the SEC had failed to demonstrate that the declaration is not expert testimony, but rather summary evidence. The reason that Fox is considered an expert is because she asserts that she's able to employ technical or other specialized expertise to assist the fact finder in comprehending the evidence or in determining a fact that is controversial. As the Securities and Exchange Commission is separate, she does not only apply elementary mathematics to Ripple's financial records. Ripple took an additional step and stated that even if Andre Fox would be classified as a summary witness, the regulator did not disclose her prior to the conclusion of the discovery process. Further confrontation is required. Ripple's request to redact and seal certain evidence and financial records data connected to the regulator's move for judgment and remedies became another point of disagreement. Ripple's request was made in response to the request. According to a statement released by the agency in May, the court should deny Ripple's request to conceal financial and securities sales information because that information constitutes judicial documents because it is at the heart of the arguments that the parties have presented in support of their remedies motion and could therefore tend to influence the court's decision regarding remedies. This information, according to the SEC, has the potential to provide further light on Ripple's previous XRP sales and might be extremely important in the litigation proceedings. On the other hand, the company contends that the prior contracts are no longer applicable because of the current modifications that were made to the sales methods. Ripple is no longer selling XRP through over-the-counter transactions that have the features that the court decided to be institutional sales at the time of the summary decision. Ripple's present sales of XRP to clients for usage in connection with Ripple's ODO product do not have any of the relevant terms of over-the-counter contracts, such as discounts granted to sophisticated counterparties. This is because no over-the-counter contracts have any of these terms. Watching for the decision of the judge, the intricacy of the legal process, and the possibility of appeals from both parties contribute to the possibility that the resolution of the case will be drawn out for years, despite the fact that it has entered the trial phase. One individual who had the idea of a resolution that may be reached pretty quickly is the American attorney Jeremy Hogan. According to him, the parties might be able to reach an agreement on a $100 million deal as soon as this summer. As a result of Ripple's 3 partial court victories that were achieved in the previous year, some people consider the SEC to be the underdog in the legal struggle. Due to the fact that each victory was followed by a price revival of XRP, it is possible that the eventual conclusion of the lawsuit could result in increased volatility once more. By the time this year comes to a close, we will be in the year 2025. There is also a post that I have published, and it is related to the Brad Garling house for the sake of establishing a level playing field, we are urging that a unified national regulatory framework be established. In February of 2023, the Financial Stability Board, FSB, International Monetary Fund, and the Bank of International Settlements are working together to build a global regulatory framework for cryptocurrency. The G20 will soon reveal this framework. In the period beginning in July and continuing through September of the previous year and ending in December of 2022, Ripple will have the opportunity to offer their opinions on the global regulation of cryptocurrency asset activities. That is absolutely correct. In the meantime, the Federal Security Service FSB ensued, and XRP is a joke when it comes to security. The Ripple reply contains the quotation once more, although there is no certainty about its appearance. A uniform approach to cryptocurrency will be created through the creation of a worldwide regulatory framework, which will also avoid future fragmentation of legislation. The lawsuit that was filed against Ripple and XRP was intended to simplify rules. Nevertheless, it also slowed down technology in order to make room for the construction of infrastructure and standards. Indeed, the Financial Stability Board, SB, International Monetary Fund, and the Bank for International Settlements having had established global regulatory frameworks for cryptocurrencies. These frameworks are required to be implemented by the G20 by the end of the year 2025. If we give it some serious thought, it would appear that everything is in order for the year 20,125 to be the year that regulatory movements are utilized and legitimized once more. Additionally, we want to keep a portion of many of these projects, such as XRP, for the inevitable future in which we know that cryptocurrency will be regulated and used extensively. As I mentioned earlier, we need to make sure that we are prepared to take profits and deduct specific percentages from many of these bags. However, we also want to keep some of these projects for ourselves. Consequently, it is imperative that we make certain that we are allotting a share. However, this is not the only thing that is coming into alignment for the year 2025. The CBDC of Russia in 2025, what exactly is going on with the ruble that is virtual? Despite the fact that 2025 and 2027 appear to be a long way off, the Central Bank of Russia is working toward the goal of mass adoption of the CBDC platform by those years. The work on this project started in July of 2023, and SWIFT revealed in March of this year that the platform would likely be released in either 2025 or 2026. It is anticipated that Brazil will launch its digital currency by the beginning of the year 2025. The executive of the European Central Bank, the deployment of the digital euro CBDC is anticipated to take place in November of 2025. While this is being taken into consideration, it is also important to note that November 2025 corresponds with the transition to ISO 22. A great number of things appear to be set for the year 2025 at this point, as I said, with Ripple and XRP.